Yes, welcome back to a short edition of the No Say Project. I like to do these. We're talking about success stories, but we're also going to make, I like to post these, of course, for obvious reasons, but look, I know I'm going to get certain criticisms, and it doesn't matter what I say and what I do, there's going to be people that are going to still criticize. So I still try to do what I can preemptively to at least show people that are new to the material and are looking to defend themselves in court that the criticism doesn't hold any water. I'm not, okay? So if you can see here, and there's a lot of success stories that we have here at MarkStevens.net. Success on, United States, Canada, Australia, New Zealand, and in Europe, in England, and Ireland, eh? And, so what I started with the last edition here of these success stories is I also posted train wreck. So I don't want anyone to think that I'm misleading in any way, that you buy the material, you do a consult, you do some role playing, and you're in for a walk in the park, that just because you can destroy their arguments, have them actually argue that the prosecution has a special privilege that they are able to make legal claims, foundational legal claims against you that set the relevance for everything else, that they were able to do that without any evidence whatsoever. That they say these things, they lie, they say jurisdiction's a trial issue only, that you can't challenge it before trial, which is ridiculous. Goes into what what I'm talking about today, about today's train wreck, which I mentioned on the show this week, and so I'm not going to go into that much detail. But it is an IRS situation where the IRS is the defendant, and we're trying to stop a 100% garnishment in Northern California. And they file their typical, when we have facts, we have actual facts and statements and dates and times that show beyond any doubt whatsoever that the IRS admittedly cannot make their claim. They admit that, and they admit that they don't need any evidence. Okay, and so even to further show that they think that it's consistent with fairness and due process to actually proceed against somebody when you don't have proof of claim. Okay, so they file the United States Attorney, they file a copy and paste motion to dismiss, and they are arguing, who would have thought, lack of jurisdiction. So they break it down into 2 points, that there's sovereign immunity and the Anti-Injunctive Tax Act. And it's amazing because they actually admitted that the Anti-Injunctive Tax Act actually exists. So we thought maybe we'll get the first federal judge in my history, and the people that I work with, the first federal judge to ever acknowledge that it even exists. Well, unfortunately, that was not to be the case. So, what happened is, now again, they filed a motion to dismiss, and what happens when you file a motion to dismiss, because this is a civil proceeding, just like the Supreme Court said back in 1974, and they're just restating a very old due process principle here, in that when a federal court reviews the sufficiency of a complaint before the reception of any evidence, either by affidavit or admissions, its task is necessarily a limited one. The issue is not whether a plaintiff will ultimately prevail, but whether the claimant is entitled to offer evidence to support the claims. Indeed, it may appear on the face of the pleadings that a recovery is very remote and unlikely, but that is not the test. Moreover, it is well established that in passing on a motion to dismiss, whether on the ground of lack of jurisdiction over the subject matter or for failure to state a cause of action, this is the important part, the allegations of the complaint should be construed favorably to the pleader. Okay? So that's why I mentioned on the show, the federal judge is obligated. It doesn't matter what he thinks. It doesn't matter what he thinks. The due process and this principle of fairness dictate he has to take the allegations as true and favorable in other cases have said, in a light most favorable to the pleader, and that's us, the guy I'm working with. So we have we have actual statements from the IRS agents who did the assessment, who are doing the garnishment. These are the Marconi and Jones, for example. These are the actual actors on record, not having any evidence, not needing any evidence. And so the judge was obligated to accept that as true, most favorably to the plaintiff. Now, the only way that you can take those admissions is they can't make their case under any circumstance. And they don't think that they have to. They're not even arguing that they can make a case because they're saying they don't have to argue their case. They don't have to prove it. So when you go to the Anti-Injunctive Tax Act, it does state the United States Supreme Court here, nonetheless, if it is clear that under no circumstances could the government ultimately prevail, the central purpose of the act is inapplicable. The attempted collection may be enjoined if equity jurisdiction otherwise exists. So when we went in there, because the defense was actually arguing the Anti-Injunctive Tax Act and sovereign immunity, the only real issue before the court was, I think it's just this one single issue, because if they didn't have evidence of jurisdiction, sovereign immunity is not an issue. So the only real issue before the court was this. Do the facts of this case, if taken as true and favorable to the plaintiff, show that the government, the IRS, could not prevail under any circumstances? And, therefore putting this complaint within this particular exception, this narrow exception. Yeah, we can admit it's a narrow exception. But the judge didn't do that. The judge started to interrogate him and asking him if he had a job. Now, what him having a job has to do with this particular issue, it's completely irrelevant. The only relevant issue was, did the facts put this within this narrow exception? That was it. The single issue, because that was the defense. And he didn't even mention it. Not a single word as to whether the facts taken as true. So here we just have, another judge who's refusing to apply the law. And again, I'm not making this up. There's Enix versus Williams Packing, and here's a very standard due process, requirement. They didn't do that. It doesn't matter, again, if the judge thinks that if he has a job, he has to pay taxes. The only thing that matters, that is supposed to matter when you are in court, is what is on record. What is in the file? See, what this judge did was ignore these due process principles and just went straight to an interrogation as if he was a prosecutor, which he may have actually been. Now, whether he has a job or not is not relevant. And he would have known that he had a job because it's a garnishment case. So clearly, this judge didn't even read the documents. He didn't even read it. He would have known right off the... and this goes to show just how unbelievably dishonest these people are. How could he go and start interrogating him on whether he had a job when it was a garnishment case? It was a garnishment case. And that is evidence right there. The fact that the judge interrogated him was proof enough he never read pleadings. So that's our train wreck this time. We're filing a motion to reconsider, but we're not very hopeful there. But we'll have that together, this train wreck with our success story. So I want to start the success stories with the one, the one. It's not a big deal. This is one where it's more in the category, hey, fantastic, you stood up to these people and you were able to get it thrown out. This has nothing to do with the defense that I recommend. This is just somebody who decided to go and he was going to defend. He was not going to just plead guilty like 95% of people do. He was going to do what he could to fight this, and he wound up not being served, and so it wound up getting tossed out. They said he was able to avoid service, and he got it tossed out. So the defendant failed to appear, but the court finds the defendant did not receive notice of the proceeding. The court states that if the state cannot provide a current address for the defendant, it will resummons. That if the state can provide a current address, it will resummons the defendant, and so they reset it. But it has been thrown out. It has been tossed out. Not a big deal. Not something I'm going to I want to hang my hat on. But we go to this next one. This was great. This is kind of a very common thing, and this is in Washington. And Christopher sent this to me. I appreciate that. And for those who may be wondering why it's redacted, unless somebody explicitly tells me you can post this unredacted, I'm going to protect their privacy. And if somebody has an issue with that, If they are lawyers, they can always look this up, and I'm sure they can find that out. But I'd like to be able to, respect people's privacy. Because the big takeaway here is standing up for yourself and not letting them get away with it. That's the big, okay? So here we've got obstruction, which is a very common thing. You're just not doing things fast enough for the police officer. Concealing vehicle VIN. And he did fight tooth and nail. He did file a motion to dismiss. He filed a discovery request. He let them know basically he was not going to go down without a fight. And he, so he would defend himself vigorously against these false charges, these code violations. And the prosecutor was, as usual, was not able to provide evidence or a competent witness. He filed a motion to dismiss for prosecutorial misconduct. And this is what we got. All of a sudden, the witness is not available. And that's a thing you have to consider, too. They don't give a damn if we're not available to answer a summons. You either have to get the summons quashed or you've got to get a continuance. They just let him off the hook here? Oh, he's not available that day. Let's not reset it. He's not available? Well, issue a subpoena. Now, you see, it's good to be one of the king's men. So here, again, like with the next one, we have some context. We know that they don't have the evidence. We know they don't have a competent witness. We know they can't comply with Brady without having to admit they have to toss it out. So here, I think the facts, even though there are more plausible explanations that we could take we could take a prosecutor at his word. Hey, the witness may not have been available. But again, even if he wasn't available, why didn't they just postpone it for a week or two? That all they had to do was postpone it a week or two to accommodate the cop. But they tossed it out. So it's plausible it's sort of in the realm of possibility that the court is so unbelievably busy that they couldn't. They just couldn't do that without violating speedy trial rights. So yeah, it's possible. I don't think that's what happened here. But but whatever judgment you draw, try to look at this with as much context as you can. So big congratulations to Christopher, and thank you for allowing me to post that. So let's go to this, and there's a lot of details regarding this that was on the last show. So with the train wreck and this success story, you can go back to to the show from yesterday or on Wednesday, the last show, and you can get a lot more details. And you can actually hear Lawrence testify or report rather what happened here. And this, of course, is in Georgia, and we have an entry of nolo prosequi, which is a voluntary dismissal from the prosecution for various reasons. They could do that; they're not seeking prosecution anymore, and. And he read this. This is what he read on the show. While this court has jurisdiction in this case and probable cause existed, the state does not believe it can prove the case as charged beyond a reasonable doubt. And this was signed by a judge. It looks like a K or an H, and that looks like a J. I don't know, but it's a legitimate document signed by one of the assistant solicitor generals. And they tossed it out. Now again, there are any honest person will admit there are other plausible explanations for why this was tossed out. However, we want to look at what's most probable. What do the facts say? Okay? We cannot just take this document in a vacuum. Okay? You have to look at the context and what led to that. And we cannot reasonably dismiss what Lawrence reported on the show as to what happened. We have to take as much context as is relevant to deciding on why this was really thrown out. Remember, this particular attorney was, basically, I believe he was being sarcastic, that the Constitution magically applied. Okay? But this same prosecutor was not able to show any evidence, walked away, making the claim that nothing they said would satisfy him. Well, yeah, if you're responsive, we'll accept that. And they also made the sovereign citizen or freeman on the land claim that the Constitution, which is a written instrument, well, that's not a sovereign citizen claim, but it's the truth, but that it's a contract. Okay? So we know that there's no evidence to prove that. There's no evidence to prove that it applies. They don't have a witness or person with first-hand knowledge. He pressed them every step of the way from that. And no, they may say that there's jurisdiction, but curiously, they didn't say, while there is evidence of jurisdiction and probable cause, because there wasn't evidence. So, again, a big congratulations to Lawrence, and I appreciate him allowing me to get this posted. And, of course, the documents will be available at markstevens.net. But this is a very common one that we have, especially when we handle situations where the judge doesn't just take over like they tend to do and not hold the prosecution to any burden whatsoever. Especially when we get these, especially in those cases where the judge actually orders a response to the motion to dismiss. And so more times than not, and there's plenty of documentation right here on markstevens.net to back that up. Where's the website there? Yeah, it's right here under the success stories. They will withdraw instead of trying to pull out one of those stupid copy and paste motions to dismiss where they're arguing that the code is somehow evidence that the Constitution applies, or they'll just argue that they're not required. They don't have to actually they don't have to set forth and prove the foundational element of their case, and that is the assumption that just because you're physically in Arizona that the constitutional laws apply, and that they create obligations on you and me. See, that's a big thing there. You never want... See, it's not just, it applies. Show me the facts that prove it actually created an obligation. Again, that's not philosophy, because they're not making a philosophical claim against you. So, don't buy into that crap either. So those are 3 success stories, 2 that had to do with the defense that I've helped with, and a train wreck that had everything to do with the defense that because I'm personally involved and I'm helping, and I was the one who did the calls with the IRS agents. But the reason why, again, I went into quite a bit of detail showing why it was a train wreck. It wasn't because my defense is ineffective as far as the logic behind it and having the facts. He had the facts and the law on his side, but what we had here was a wholesale refusal of the judge to comply with basic principles of due process, that being here taking the allegations of the complaint as true. It should be the facts. The facts of the complaint should be construed favorably to the pleader. I guess the factual allegations accepted as true. So, hey, it comes down to this here, people. If the IRS or these traffic court people or any of these bureaucrats or their shills, their supporters, if anybody who's making the claim that these magical laws, the sacred writ, okay, maybe from Zeus himself, these laws, constitutions and codes, if there was any proof to prove their claim that they actually apply and create obligations, they would just provide it. They wouldn't refuse to comply with basic principles of due process, such as, construing the allegations favorably to the pleader. So, and that'll be posted here at markstevens.net under the success stories. But if you disagree with what I've presented here today, you think there is evidence proving these laws apply and create obligations, therefore given jurisdiction, call into a live broadcast. I would love to hear your logic and your facts. But till then, salud.